Just thinking, how do you feel today about the future? I know there's a lot going on in the world, but generally, your children, your family, if you have a business, your assets, personal care issues, healthcare decisions, pets, all these things that might give us a lot of stress, charitable donations. And so my point again is, having knowledge and doing some planning can help you feel secure about the future. If you don't do anything, all of this is unknown, and it does create anxiety and fear and insecurity. So again, my goal is to help you find peace of mind. There was a study done by a palliative care nurse. This doesn't necessarily have to do with estate planning, but these were major regrets of the dying. One was, I wish I'd spent more time with the people I love. I wish I'd lived up to my potential. I wish I had let myself be happier. And so really, what is happiness? So again, having some peace of mind, and I think if you do estate planning and you have your kind of ducks in a row, so to speak, you can be happier. You can focus on these other things that are more important. And also, if you do take the opportunity to do estate planning, maybe think about these things too, because it's just inherent in what we do. We have to talk about those end of days. So we don't want to have regrets, okay? So a lot of people avoid planning. This is just my little funny cartoon where they're talking about, yeah, we should do something, and then he says, gosh, why should we care? We'll be gone. That's their problem. And then she says, yeah, right. Well, at least we talked about it. So that's kind of the method of a lot of people. What do all these people have in common? Abraham Lincoln, Martin Luther King Jr., Jimi Hendrix, Pablo Picasso, Howard Hughes, Aretha Franklin, and Prince have in common. No will. And Aretha Franklin has a little star by her name because they did actually find two versions. I think they were handwritten documents after they thought there was no will. There was something in a filing cabinet, and then something in a notebook stuck between her couch. So it just kind of caused a lot of disputes among the family. But so anyway, if you haven't done anything, it's okay. You're kind of normal. Only 32% of Americans report having a will. Only 20% have a trust. 14% of U.S. adults give lack of assets. Like, people think, I don't really have that much. I don't need to do anything. 34% of people between the age of 35 and 54 have never discussed estate planning at all. 52% don't know where their parents store their estate planning documents. So these are just kind of things that is very common. Some of the reasons that we avoid estate planning, it might be because of the economy right now and costs, and it is an expense that you might put lower on your priority list than paying for your groceries and things that cost more to everyone. Greater focus on essentials. Procrastination is kind of a big one. A lot of people kind of have this in the back of their mind, we should really do this. I talk to people all the time, and they're like, gosh, I've been meaning to do this. Just procrastination. Some people think it's not necessary. Like I said, they think they don't have enough, or that it's just going to happen automatically. Takes too much time. I do run into people that have a hard time finding the time to do it. Some people are just very private people. They don't really want to reveal all the information that they have to do. It's too expensive. I have had a few people that have a disagreement with their spouse. A lot of times it's, not even necessarily the blended family, but that might be a situation where you kind of disagree how things are going to go. But if you come to me, we always just work through those disagreements. So fear and indecision. Death is one of our top fears, so that's kind of one of the things that holds people back too. But generally, I would say at least every 3 to 5 years, kind of revisit situation and think about things like, did somebody die, or somebody born, birth, divorce, are people that are in your plan now, having problems, drug problems, or other problems. So yeah, just to revisit or if you acquired new assets or sold something, that would be general rules there. Okay, so I have a few examples. And consequences of not doing any planning: increased costs, delays, the assets don't go where we would have planned, like you just mentioned. If you don't have anything in place and you're getting to the age where you're a little more vulnerable, we see undue influence even from caregivers, neighbors, even people's own children. There's family disputes, and then there's a lot of uncertainty and worry. So one of the big things too is probate, and we'll talk about why we don't want to do that. Conservatorships, if somebody loses capacity when they don't have any documents in place, the only way to help them sometimes is going to court with a conservatorship. So all of these things are not pleasant things, and worry does not help us at all. So I have a couple examples, real life examples that I've come across of people, just to kind of maybe just demonstrate. So I have a couple examples, real life examples that I've come across of people, just to kind of maybe just demonstrate. So next is Mary. She had no family. She did have a lot of friends. She wrote a trust and a will in 2011. She did some funding of her trust, which we'll talk about, which is putting assets in the trust. She actually left a lot of her accounts and assets out of her trust, including her house. So she was kind of at the end of her life, she realized, I think, that she needed to do something. So she had made an appointment with an attorney to update her trust. Also during this time, she hand wrote this will, which is very interesting. It was leaving some money to a few people, a lot of charities, and appointing her friend who was helping to take care of her her 2 cats for 7 years. She specified the nice, this particular snacks that the cats liked, and so the will said that this her friend was to take care of the cats for 7 years. But it was kind of then she passed away, and so then it became very confusing. Like, did she mean to amend her trust, or was this a will? Is this completely separate? So basically, this all ended up in probate court, and it's still going on, and it will go on for that 7-year period. So that's another thing just to mention about how important it is, if you do create a trust, to get all those final details done and fund the trust, which we'll talk about. Unnecessary costs for her because the probate fees are more than $70,000, $76,000 and ongoing. So that's crazy, isn't it? She did not do any planning at all, really. She had friends. She does have family. When she died in her garage in her car, her friends came. In the next few days, we hear from neighbors with a moving truck, came in and took a bunch of stuff. Nobody knows what it was, but it's gone. Looking through her house, they did find a will, another handwritten will, but it only addressed a few gifts, specific gifts to her friends, may or may not be the same people. But then she had family. Some were kind of half-sisters, brothers, and it ended up in a family dispute over who got to do the probate. So competing probate petitions, that's still going on as well. It did all work out, but that was just another, way of showing that when you kind of lack planning, you're just asking for extra costs, disputes between your family, possibly. Her unnecessary costs are at least $30,000 because her brother's going to handle it without taking any fees. Otherwise, it would be double that. So lots of delays involved. What is an estate? Some people say, "Gosh, I don't really have an estate. I don't have a lot." But really, everyone does have an estate, and there's lots of components to it, and especially for estate planning. It might include different things like, if you have children, who would care for your minor children? Power of attorney is a component. We'll talk about what that does in a minute here. Handling illness, incompetence, or disability in the future, just planning for that. Having an advanced health care directive, which is appointing someone to take care of your health needs for you and decisions. Revocable trust. Not everybody needs a trust, but a lot of people do here in California, especially. A will. Might be HIPAA medical releases so that your family can communicate with medical providers without being blocked. Something to consider: life insurance if it's appropriate, especially if you have children or a spouse that you want to support. Something happened to you. Some of us are lucky enough to have retirement plans. Something to consider. There's what we call non-probate transfers, which are transfers of assets that occur outside of probate through beneficiary designations. And that would be, for example, those life insurance policies, IRAs, and retirement accounts usually. Something to think about: digital assets. We all have a lot of digital assets, whether we want to or not. Online accounts, devices, usernames, passwords, all these things that if something happens to you, your family may not be able to access them if they don't have those passwords. And of course, pets, which are so important to some people. They're almost like their children. Personal belongings, all of these things. So, even if you don't have a lot of assets, everyone has their body and their health, and so those are things to really think about. And you just don't want to be in a place where you have to go to court to take care of things like incapacity. Okay, then the next thing is incompetency, disability planning. 50% of the population will be affected by a disability or some sort of incapacity, whether it's permanent or temporary. So if you don't do any planning, that's where, I talked about those conservatorships. Someone else will be making those decisions about your finances, your personal care, where you live, what type of place you go to, medical treatment. And that's another reason that we need power of attorney. So a power of attorney is a formal agency relationship. People ask me all the time, what does durable mean? It just means that once your agent is acting on your behalf, that doesn't go away. Like, let's say you become incapacitated and then you're okay. Once that agent is acting for you, if it's a durable power of attorney, it's going to remain in place unless you revoke that power. So power of attorney can be effective immediately, right when you sign this document, or it can be what we call springing, which means it only takes effect if you actually become incapacitated. And so why do we need power of attorney? This is for financial matters, property management, and it's during incapacity. So if you pass away, power of attorney goes away. So I do hear all the time people trying to use a power of attorney after somebody died, and they're like, oh, well, they wouldn't take it, but that's because it does go away. So it's only for living, when you're alive and dealing with incapacity. And it's for things like bank accounts if it's not in a trust, which we'll talk about in a minute. Things like dealing with a retirement account, or if somebody sued you when you were incapacitated, dealing with pets, mail, credit card companies, all these things that are part of our lives, financial, where if you can't do it yourself, you need somebody to step into your shoes and manage those things for you. Okay, they can be tricky. Banks in particular seem to be very kind of strict about accepting power of attorney because I guess there's a lot of abuse that happens. And so you have to just do your best. And I like to use statutory forms with a supplemental form because those are recognized by banks. We tend to have less trouble having them accept them, and then you can also collect attorney's fees if the bank says we just won't accept it and there's not a good reason for that. I always tell people to, you're presenting these documents and just don't always expect everything to go perfectly smoothly. Even when you're using all these legal documents, sometimes it can be frustrating. And yes, like I mentioned with my first example, these are subject to abuse, and I think that's why there is so much protection around them. Okay, healthcare directives. Only 30% has a healthcare directive, and this is just an example of he's thinking about creating one. His little friend there is writing it for him, and it says, tell me if I have a headache, tell me if I'm itchy, tell me if I complain too much, and then he says I might have some edits. And there you go, complaining again. That's where you appoint a trusted agent to make personal and medical decisions for you. It also includes so it's kind of a twofold thing. You have that agent to make decisions for you, and then the other component is you're writing down all your kind of end-of-life wishes, how you want to be treated if you're in like a vegetative state or a coma or something like that. Do you want to donate organs? Do you want to be cremated, buried? All those kind of yucky things to talk about, but it's good to just kind of get it out of the way. And then another important thing that people don't always think about is this person will be deciding, like if you lose capacity and you need care of some sort, they're deciding, do you get in-home care? Do you go to a nursing home? Do you go to some other level of care? So it's really important. I think this document is so important to not only choose an agent person that you really trust and that you've kind of discussed how you feel about these things, but also if you have wishes about where you would want to live, that you write them down, or certain things that you want done for you, because you just have to remember you might not be able to communicate those things, and this is your life, and it might be the final days of your life. So that's why I think this is a super important document.
Are those wishes put in your will then? We put the steps of what you'd like them to do in your will, not in the healthcare directive?
So I put them in the healthcare directive. Yeah, I think you can put like disposition of remains in the will, but I always put everything in the healthcare document because sometimes the executor who's named in your will is a different person than your healthcare person, and I just think that person that's managing that is, should have all those instructions there, and they're the one that would deal with, like if you pass away, they deal with the funeral home and the mortuary and make all those arrangements too. Okay. A document that goes along with that is a HIPAA privacy release. And the reason why that's important is because our HIPAA laws are such, probably a lot of you know a lot more about them than me, but they are such that your medical providers can say, gosh, we just don't talk to anybody about this patient unless they release their information. I've even had it where they won't talk to your spouse. I've had a client where his wife was in a very critical situation in the hospital and he wanted to move her, and because they didn't have any documents in place, he wasn't able to get her medical records or do anything. He was really shut out, which was, sometimes it seems very illogical, but sometimes people just follow whatever rules they're required to follow. Okay, so now we'll talk about trusts and wills, which is kind of what most people think of when they think of estate planning. Why do you need a trust? So one of the main things in California to have, or one reason, is to avoid probate. I have this box here that I'm going to have representing probate, also known as House of Horrors. So certain assets will go through probate if you don't have them in a trust. So the cost of probate is very high. It's set by the probate code and it's a percentage of the value of the estate. So even if you have a lot of debt on that property, for example, they're going by the value of the estate. And as an example, if you have one house that's $1 million house, it's going to cost probably about $50,000 just to get that one asset through the court system. I would say the time estimate here is low because it's really backed up right now. The courts were closed down for several months during the pandemic, and so there's still a backlog. So I would say it's a minimum of 18 months. It's totally public proceedings. You're really at the mercy of the court and the judge's schedule, and if you don't even have a will, you don't have any say in where the assets go. It's just all, we follow the probate code. Okay, so how does a trust work? I like to think of a trust like a bucket. You use this bucket to hold certain assets. So the probate threshold is $184,500. So if you have an asset that's worth that much, like a house or cash in a bank account or a stock account, that would be subject to probate unless you put that in a trust. So if you put it in this bucket, like a virtual bucket, for some reason, we completely avoid that probate process. It becomes a private process where you can create all the instructions that you want that go along with this bucket. You appoint a trustee or a successor trustee to manage things, either if you become incapacitated or when you pass away. And so during your lifetime, you're holding that bucket and controlling everything in there. And then when the time comes, you can hand that off to your trustee and everything goes along with it. The typical things, I think I'm going to show you right here, that go in your bucket. So right now these all go through probate. So this is your bucket. You will have, even if you have a trust, you're going to have I'll call it a box. Oh, whoops, that would be helpful, would it? A box of things that actually don't go through probate, but they're still not in your bucket. So one of the big things is real estate, your house. So that definitely goes in your bucket, okay? Bank accounts. So we can have transfer on death type beneficiaries on a bank account, but for most purposes, a lot of people don't have that. And also, that's not a perfect way to pass these assets. So I always recommend put your bank accounts in your bucket. Stock accounts. So not a retirement account, but a lot of people might have mutual funds, stock accounts, brokerage accounts. Those are ideal to go in your bucket. If anybody has a small business, like an LLC or a corporation where you have stock, those are subject to probate. So if you didn't have it in your trust, and like sometimes people have a buy-sell agreement or something where it does pass, but if not, you should have it in a trust. 401k retirement plans. So those are one of the assets that typically we name beneficiaries. So they actually don't need to go in our bucket, they go in our box. Okay, same thing with an IRA because we have beneficiary designations. Now sometimes you might have the beneficiary designation pointing to your bucket. It might be your trust. It just depends on your situation and your plan. Like a lot of times if you have young children, you would name your spouse as a primary beneficiary, and then you would name your trust as your contingent beneficiary so that everything, if something happened to both you and your spouse, then everything would get gathered up into that bucket. Okay, royalties, I've come across, these are a little tricky, but typically if it's like oil and gas, or I've had people that had books or music royalties, we try to get those in the bucket. Okay, individual stocks, I think I already said that, but like savings bonds, those kind of things, they go in. Stock options, now those are tricky. If you have stock options with a company, you don't actually own them until they're vested or you exercise that option. So we can't always get them in the trust, but until you've exercised the options, and then you own the stock, and then they would go in your bucket. Vehicles. So vehicles are a little bit different. As long as you don't have a probate, vehicles, the vehicle code says you can pass them with DMV forms. So typically, it's not worth the fees and the extra, effort to change the title into your trust. So these can be outside in your box, okay? And then, personal property like jewelry, clothing, all those things that we don't have official title change on. Thank heavens, we don't have to change title on those. Collectibles, artwork. So the way we handle that is with a specific document that assigns those to the trust. So those do go in your bucket. And sometimes people, very common, they loan money like to their child or something to help them buy a house or something, and they've created a promissory note. So that's something that's really important to assign, again, to your trust, so that if something happens to you and that note hasn't been paid off yet, your trustee then can take over and still collect those payments. So that does go in your bucket. And then life insurance. So this is, are you laughing at my picture?
No, I'm laughing at, it's horrible to say, but if they're gone, it's like you should have to pay back that loan.
Oh, yeah, that's true.
I'm like, sorry.
Yeah, they thought they were off the hook. Okay, so life insurance is another thing that you might have, especially if you have a spouse or children. So typically, these pass by beneficiary designation. So my usual recommendation is have your spouse, if you have a spouse, primary beneficiary. Then it depends, are your kids all grown up and you're okay with them having it if something happened to both of you? Or are they younger and you want the provisions of the trust to apply? The one thing that I have seen, this was my example of Mary. She actually it wasn't on a life insurance, but it was on her retirement account. She named her estate as the beneficiary. So guess where that goes? That goes in the House of Horrors, probate, if you name your estate. So if you have a person or a trust, then it goes actually here, beneficiary might be directed into that bucket. So our estate tax exemption right now is huge. So this year you can pass 13.6 million without having to pay, or your family wouldn't have to pay estate tax. Those laws are going to change at the end of 2025, next year. That will be reduced about in half. So each person will have 5 million plus some little extra for inflation you can pass to your family without paying estate taxes. We also have something, without getting too far into this realm, but we have something called portability, which means you and your spouse basically can combine your estate tax exemptions as long as you let the IRS know and when it passes. So if you're married, you can kind of double that if your whole estate is over the one exemption amount. But we can use trusts somewhat to plan for the estate tax exemption. And then I just want to say, of course, we have an election coming up, and who knows, the laws could change, but that's the current laws.
And if you only have, say, 4 or 5 million today, can
Yeah.
you do a trust before 2025 with the intent of making it up to 13, 14, whatever it is now, and get grandfathered?
Yeah, well, okay, so creating the trust doesn't really affect the exemption. You can plan for it, knowing how the laws are going to change, but if you are anticipating accumulating wealth, you can do some planning. There is this kind of window of time, like if you have a lot of wealth now, where you can use your high exemption in the next couple of years to give property away, and then you've used more of your exemption and gotten more out of your estate, but then going forward you won't have your exemption anymore. So yeah, so we really can't, it won't necessarily help to preserve the exemption unless you actually use it, if that makes sense. Okay, so control of your assets during incompetency, again, or incapacity. So again, you're appointing a trusted person to take care of all the things here in this bucket. It really operates much like what we think of as a will, where you're directing where all your assets go, but with a lot of instructions. So if you do have children or beneficiaries and it's kept in the trust rather than distributed to them, they do have some asset protection. So people ask me all the time, oh, if I have a trust, then I'm protected if somebody sues me, right? Well, no, that's not right. A revocable trust does not give you asset protection because it's revocable. It's very flexible. You can take all this stuff out at any time. You can remodel your bucket. You can start over, make changes to it as much as you want. And for that reason, you don't get asset protection. But when you pass away, that's the time when your trust becomes irrevocable. And so in that way, your beneficiaries are protected because it's irrevocable. There might be somebody else in charge of it. And so they're, like, for example, if they're in a bad marriage or something, or they have problems, they do have protection from creditors, but it has to be kept in the trust. That's kind of the trade-off. Okay. We do have Medi-Cal recovery protection. I know that the Medi-Cal laws have changed a lot in this last year, and I'm definitely not an expert in that area. But one of the things is that, well, right now, as I understand it, Medi-Cal, qualifying for Medi-Cal, which is California's version of Medicaid for low-income families, needing for long-term care, for example, it's going to be income-based to qualify. And so you could have a house and still qualify for Medi-Cal. But if you don't have your house in a trust and you pass away and you collected Medi-Cal, they will come back after your estate and they'll want to be paid back. But then for some reason, if you put your house in a revocable trust, that Medi-Cal recovery provision does not apply. So, so it's kind of, that's a benefit. So, and then, if you do have like a relative or a child that has special needs that would be, where they would be disqualified from benefits if they inherited a bunch of money, you can keep a special needs trust for them to pay, like, supplement their needs when you pass away. More advantages. Oh, okay, so capital gains exemption is preserved. So when we inherit property by reason of death, you may have heard of a step-up in basis. So what that means is, say you pass away, your house, and you say you just have a house, your house would be revalued at your date of death, and if you give it to someone at that time, they could then sell it and they don't pay any capital gains taxes, even if you had that house for 50 years and it went from 30,000 to 2 million, which I know some people in this area that have that situation. So that's really nice. So that's a great benefit that we have under our current laws. That also applies to stock, for example, appreciated stock or other assets that are subject to capital gains. So anyway, the point is to if you put it in your trust, you preserve, that doesn't change at all. That's all preserved. Stepped up basis. You can also create incentives for, like, if you have children and a lot of people are concerned they want them to go to college or not turn into a trust fund baby where they're not working or something like that. So you can put all kinds of incentives, bonuses, just think that might be, unfortunately, if the worst happened to you, that's the only way you have to really influence your children or your beneficiaries. And so providing incentives, instructions like that is one way to influence them. So charitable remainder trust, this is like its own presentation, but we can create them within a revocable trust that doesn't take effect until you pass away. And one way to use them that I'm kind of excited about, because they changed the laws, kind of happened in 2020 and it was overshadowed by other events, but they changed the laws, you might know, so that if you inherit an IRA and you're not a spouse or a certain special beneficiary, you have to take all of that out within 10 years. And so a lot of people would rather, you used to be able to stretch it out for your lifetime. So this is a way that we can kind of get around that. If you have some charitable interest too, you can create a charitable trust inside, so it takes effect when you pass away, and that would be just for an IRA type asset. And so what happens is then that is liquidated. Charities or charitable trusts do not pay income taxes. So it could all be liquidated and reinvested, and then the instructions of the charitable trust could pay your beneficiaries for their whole lifetime, pays a percentage, their whole lifetime, more than one, or a term of years. And then what happens though at the end of that is then what's left has to go to a charity. So it's actually kind of a nice way to leave a charitable bequest to benefit your family still. We can also create these during lifetime. If you have, for example, sometimes people have a rental property that's highly appreciated, and then we have that capital gains issue. They're wanting to kind of transition it. So what you can do is create it during your lifetime. You put a different type of bucket, put that house in that bucket, then you can sell the house. And again, that trust does not pay taxes. So you just avoided all of those taxes. You get a charitable deduction. You set it up so it's paying you a percentage of the assets reinvested for your whole lifetime. And then at the end of your life, then it does have to go to charity. But a lot of times people find that there's so much tax savings, they can afford a nice insurance policy to replace it if they wanted to, still have assets going to their family. So, like I said, that's a whole presentation of its own, but kind of exciting. Okay, so a lot of times people say, gosh, what's the difference between a will and a trust? Do I still need a will? And the answer is yes. When you have a trust, this bucket, you still need a will. It's called a pour-over will in this case, and it's really more of a safety net. If there's something, like let's say this is my rental property that I forgot for some reason to put in my trust, and I died. So what would happen is the will would direct this into my bucket. Or I always use the kind of dumb example, if you bought a lottery ticket or something and then you passed away. But important is that wills still have to go through a probate process of some sort, but at least it would direct to the trust so that your instructions would be followed. Okay. Something to think about is life insurance. It's depending on your situation, your family. A lot of times people might not need life insurance, but it's good to just think about, gosh, do I need it? If I have children that I want to fund a trust and I don't have a lot, it's a good way to kind of take care of that. And so I think it's good to just see what you have, because some people think they have a life insurance policy, and then when we looked at it, gosh, they only actually had a AD&D policy that would only pay if they died in an accident, or they couldn't understand why it was so inexpensive, and that was why. So it's just good to think about it, have a professional review your coverage, decide if you need coverage, how much you need. And then something else to think about is long-term care. I know a lot of people in here are very aware of the costs of long-term care and the amount of people that will need long-term care. They say 70% of people over 65 will need some sort of long-term care in their lifetime. More than 40% of people over age 65 will require care in a nursing home. These are some of the factors, like if you are getting older, if you live alone, you're more likely to need care. Women, I guess, are more likely to need care if you're not healthy. And so basically, the older you get, the more likely you're going to need it, unfortunately. This is just, I think this is right, the cost of long-term care in 2038, that's not that far, is projected to be, almost $700,000 for, I think that's like nursing home type care, but it's overwhelming. So I'm always happy when I come across clients and they have a long-term care policy. It's kind of exciting. So some common concerns are, I don't know who I would name, and these are things that kind of keep people from doing the planning. Your trustee, executor, your power of attorney, they can be family, they can be your beneficiaries, they can be friends. If you really don't have anyone, there are private fiduciaries, people that just that's what they do. They're licensed and they know how to do all the administration. Banks, trust companies are not always my favorite. Sometimes you need a larger estate. And a lot of times people feel like they're not as personal. They definitely charge fees, although anybody can charge a fee for doing the job of administering your estate. So some common concerns are, I don't know who I would name, and these are things that kind of keep people from doing the planning. Your trustee, executor, your power of attorney, they can be family, they can be your beneficiaries, they can be friends. If you really don't have anyone, there are private fiduciaries, people that just that's what they do. They're licensed and they know how to do all the administration. Banks, trust companies are not always my favorite. Sometimes you need a larger estate. And a lot of times people feel like they're not as personal. They definitely charge fees, although anybody can charge a fee for doing the job of administering your estate. Sometimes too, are there any disadvantages? I honestly cannot think of any disadvantage other than the cost of doing it and going through the process. Of course, I wouldn't call that an advantage that you get to pay someone to do it, but it's just protecting you in all areas, your finances, your health, and it's, again, giving you peace of mind. What if I want to make changes? So again, this revocable trust is something you can change as many times as you want. You can change it every day, every week. You probably wouldn't, but again, to your point, you probably at least think about it, once a year or every 3 years or something like that. There are shortcuts. So one way that people try to take a shortcut with specifically real estate a lot of times is adding their child or someone as a joint tenant on their house. So it can be okay because it is a less expensive way to pass that property because joint tenancy has right of survivorship. But there's lots of unintended consequences. First of all, you're giving that person a gift. When you put somebody on title to like your bank account or your house, you're also just inviting all of their liabilities, creditors. If they get sued, guess what? Your house might be in jeopardy or your bank account. That happened to a client of mine. She didn't want to spend the money to create a trust, so she just decided to put her daughter on her account, which was her whole life savings, like $300,000. And her daughter's dog bit the daughter's dog bit the gardener. And so they called me in a panic. He's gonna sue, and she's on the account, and so they had to really scramble to try to get her off because that was everything that mom had. So, like I said, sometimes it can work for people, but it's just good to think about consequences. And when we're dealing with real estate, there might be property tax reassessments that happen. So I would say just get some advice before you make those moves. We can do gifting. You can gift your house away or your things right now, but then of course, you cannot keep your claw in it. So once you give something away, it's gone. And you might think, well, they're going to take care of me or whatever, but legally, somebody who's been given everything doesn't have an obligation. They might have a moral obligation.
If they do the joint tenancy and the gifting, that changes the step up.
Yes, true. Yeah, exactly. Yeah.
And then you have to pay.
Yeah. So if you give someone your house, you're giving them your basis, so they will not get that step up. That's a really good point. We can use beneficiary designations, actually for sure recommended on things that require them, like life insurance policies and such. You can put them on bank accounts. Again, it's not perfect because if you become incapacitated, then they're having to use power of attorney, and remember how banks are kind of hard to deal with. If your beneficiary dies, you may not have taken care of all those steps, whereas a trust would take care of to the very end. I drive people crazy with, well, what if this person's gone, what if, till we cover it all. So, not perfect. I guess you can spend everything. You can cash your last check on the last day of your life, and then you don't have to worry about it. So yeah, just be aware of any unintended consequences. And then I know there's a lot of options out there to do it yourself. There's certain free, if you sign up for this, you get a free trust plan. There's online services, all of that. But I do come across a lot of times, attorneys always say, gosh, that's our insurance of for sure having a new client, because they're either, you might have missed something, done something that was unintended, or just not having a good quality product. A lot of times people checked some box that they didn't really know what that meant, and it wasn't really what the best plan would be for them. And I do find that, certain unnamed company, you get this beautiful, it actually looks really nice, binder, engraved, and they think, oh, I have this trust and I have this plan and it's so great, and we did our planning, and then we look and it's like, oh, well, you didn't put your house in your trust, or you didn't fund it, or you didn't actually sign some of these documents, or whatever it was. So it can give a false sense of security. And just remember, if you do make mistakes, it can affect your family relationships. The test may not happen until you're gone, or you've become incapacitated and it's too late to do anything. Could affect, just using the improper language might affect the disposition of your property. Don't know if you can effectively plan for births, deaths, all these things that happen to us if you're, not a trained expert. And then I always, potential tax consequences. I always ask people if, would you do surgery on yourself? Because there's always a YouTube video out there to do anything. You can learn how to change a tire, rebuild a car, probably do surgery, but probably not a good idea. Okay. And I always consider my role as an attorney not just someone who hands out a form and goes through a questionnaire, but a counselor. So I think there's a lot of value in seeking a professional. So this is I don't know if you can see that very well. I have this in my handout too, but it's a checklist where if it does apply to you, I recommend you kind of pull things together and have in one place, if it's your house or wherever you keep your important documents and things. You got a category of financial documents, any of your estate planning documents. Do you have like a prepaid funeral burial plan? Healthcare, big category there. All your healthcare documents, end of life instructions. Do you have a list of medications that you're on? Any kind of insurances that help you. And then your list of advisors, which might be, financial advisor, accountants, realtors, insurance agents, all your medical professionals, if you have like a senior living care consultant, that would be something. And then other basics, just like those basic documents, driver's license, your birth certificates, marriage certificate, all these things that might be needed. If you have a safe deposit box, does anybody know where the key is? Or do the right people know? If you have a safe. One thing I don't have on here is firearms too. So I've found that a lot of people in Orange County seem to own guns. And it's just really important, I think, to properly take care of those, not only for safety reasons, but just so that this important asset is going where you would want it to go if something happens to you. And then that is it. So I just urge you to take control, protect your future so you can feel secure and enjoy your life. Oops, I guess that was it. All right, thank you. And if you have any questions, be happy to